Hello, I'm Advocate Nikita Pandit and I will be speaking on the registration of copyright, and you're watching Legal Bites. The main objective of this video is to understand the procedure of registering the work under the copyright and the advantages of registration as per the Indian Copyrights Act of 1957. The Copyright Act of 1957 provides the protection to the original works like literary work, dramatic work, musical, artistic, cinematographic, and sound recordings. Copyright protects the expression of ideas and not only ideas. The work does not require any registration. However, registration of copyright poses as an evidence for the ownership of the copyright in the work. In order to deal with the registration process, a copyright office is set up under Section 9 and the registrar is the head of the office. They keep a register which has the name of the registered copyrights, their names, addresses, and their work titles. For registration, the owner or the author of the work has to follow the procedure which is given in Section 45 of this Act. The application for registration is to be made along with a fee to the Registrar of Copyrights. Where the work is artistic works, and it also can be used for the purpose of any goods and services like logos, packages, brand, symbol, label, the certificate is also to be obtained from the Registrar of Trademarks, who is appointed under Section 3 of the Trademarks Act 1999, who is the Controller General of Trademarks and Patents, so that the work which is to be registered under Copyright Act is not deceptively similar to the trademark which is registered or is applied for. The application is made online. After the online filing, within 30 days, the hard copy of the application and the required documents like Form 14, Power of Attorney if it is required, no objection of the applicant if the applicant is not the author of the work, and if such work is such that it can be used in goods and services as mentioned before. The CD, flash drive in case of movies and sound recordings, agreements if entered into such as in case of transfers. The certificate of trademark registrar is also to be attached. If someone's portrait appears on the work, there must be no objection certificate acquired from him. 2 copies of the work must be given in original along with the title of the work. Before application, the applicant has to give the notices to all the persons who may be interested in the work to be registered. After receiving the application, the Copyright Office does the examination of the work and sees that the application complies with the rules and regulations and statute. If there is any problem with the application, a notice is given to the applicant and he is asked to fulfill the compliance. After fulfilling the formalities, there is a waiting period of 30 days. During the 30 days, if there is no objection, the registrar can allow or disallow the registration. Before that, both the parties are given an opportunity to be heard, where the parties can appear on their own or through a pleader as per Rule 70 of the Copyright Rules of 2013. If there is any problem, then the applicant is given a period of 45 days so that the applicant can remove all the faults. If any person who has the problem with the final decision of the registrar regarding the registration, an appeal can be filed before the commercial courts under Section 72 of the Act. All the entries made in the register are published in the official gazette by the registrar. Now let's see what can and cannot be registered. If a photo is taken of the person and no objection of the person appearing in the photo is necessary to get the copyright. If the picture in such photo is purchased, the purchase agreement of that photo is to be given along with the application and other documents. The same rules apply to the collages. If the photo is of a famous person, the NOC is not required as such, but that photo should not be offensive or objectionable in any way. In case of animated characters, sometimes they have the potential of being registered as trademarks for the brands. In such cases, the trademark registrar certificate is also to be given along with the application. In case of board games and card games, the copyright can be made only to the extent of graphics and creativity and not of the idea behind the game or methods of playing. For example, chessboard. The designer of the board, if he designs it differently, the graphics can be copyrighted but not the moves of the games. If the work has any logo or symbol belonging to the government, it is important to get no objection from that particular authority, otherwise it cannot be copyrighted. In case of certificates, they only attest a particular fact and there is nothing creative in certificates. For example, XYZ person won the tennis match, or Y won the drawing competition, or X is eligible for this job. It is important that any work involves substantial skill, labor and capital of the author which is not present in the certificates. The blueprints or drawings of an architectural work can be copyrighted. When the stage arrangement is made, such as for the concerts, reality shows, sets, the photographs which are taken of that set is copyrightable. Every photo in such case form the different work, and if a person wants copyright in all the photographs, he has to make different applications for each photograph. In case of the lectures, sermons, speeches, they can be copyrighted only if they are put into writing or in a digital form, that is expressed in some medium. Letters can be copyrighted, but not the standard letters which everyone writes. There must be something creative in it. In case of judicial pronouncements, if the person has put his skill, labor and capital in putting head notes, editorial notes, footnotes, or has made a compilation, the copyright can subsist in the work. But the copyright does not persist in the fact that the judicial pronouncement makes. It is only in the other creative part. In the commentaries, the person explains the knowledge by giving in his own examples, cases, and also uses his own skill and labor to come up with new ideas to explain the concept. That can be copyrighted. A cinematographic film can be copyrighted, but the title of the movie cannot be copyrighted. The same applies in case of movies. In case of websites, only the arrangement can be copyrighted, that is the content. The work which falls under the definition of the copyrightable work as per the Act can be copyrighted, which is on the website. Only a word or 2-3 sentences, slogans cannot be copyrighted. The mathematical formula and algorithms cannot be copyrighted as they are only ideas. The idea itself is in the graphical form and in fact it is a fact. Fact cannot be copyrighted. Some cases in this case are Pepsi company and others versus Hindustan CocaCola. Pepsi filed a suit against Coca-Cola to stop them from using Ye Dil Mange More in their advertisement and also their roller coaster advertisement. This was for infringement of copyright and trademark. They also contended that Coca-Cola used the word papi in their advertisement, which was deceptively similar to Pepsi. Pepsi claimed that Coca-Cola disparaged their name, and this means that when other brand is shown of less importance or undervaluing it or disgracing it by calling it Bachcho Wala drink. In the commercial of Coca-Cola, a boy was called from audience and he says Pepsi, which can be clearly seen by his lip movements, but the bottle has the name and it can easily be understood that it meant Pepsi. It was held that there was a similarity and the work originally belonged to Pepsi. Coca-Cola was restrained from showing certain content, including the advertisement. Another was the case R. Radhakrishnan versus Mr. AR Murgados. The plaintiff, a public-spirited person, made several projects on social issues on eradicating the social evils. He made a short film on the foul treatment which is made to the transgenders and titled it Raja Rani, and he registered it. He got to know that the respondent was going to make a film named Raja Rani. It was held that the titles, like the names of human beings, are the identities of the movies. Exclusive copyright cannot be given to them, and so the injunction was declined in this case. So these are certain important provisions regarding the registration of copyrights in India. Thank you.